Can you be sued if you infect someone with coronavirus? The answer is yes. Definitely yes, as long as the circumstances are right. One man in New Hampshire could end up being the first defendant in a coronavirus lawsuit. As background, an unidentified hospital employee became New Hampshire's first coronavirus patient, and he was told to self-isolate. Instead of following this eminently reasonable order, on February 28, 2020, this unidentified man attended a function at the Dartmouth Business School. At least one other person, another man, who came into close contact with the first man, the one that was told to self-isolate, also developed coronavirus. Now, the question is whether this second patient can sue the first patient for infecting him. And believe it or not, there is a lot of case law that supports a lawsuit like this. In fact, there is an enormous body of case law dealing with negligent transmission of sexually transmitted disease. These cases prominently deal with HIV, and there's a cluster of them in the 80s and 90s, although you still see these types of cases being filed today. Some state legislatures passed criminal statutes that make it a crime to knowingly expose another person to some diseases. For example, 720 ILCS 5/12-5.01 makes it a felony to knowingly engage in certain conduct if a person knows that he or she is infected with HIV. Most states have similar statutes on file. However, those statutes largely deal with well-known serious diseases, such as HIV, tuberculosis, and hepatitis C, and will largely not address coronavirus. That still leaves two common law causes of action that an infected person can rely on. Those causes of action are battery and negligence. Let's explore battery first. Battery occurs when a person intentionally makes a harmful or offensive contact with another that causes damages. So how could that apply to our situation with the New Hampshire hospital worker that broke a quarantine order? To start, intentionally does not necessarily require that the hospital worker knew that he was going to infect someone else, or that he even intended to infect someone in the strictest sense of the word. Rather, in law, intent is more of a spectrum of conduct. In the case of our New Hampshire medical worker, his conduct could be described as reckless, because he knew or should have known that he was placing others at a high risk of infection. And a person who acts recklessly is just as liable as a person that acts intentionally. In fact, in our case, the New Hampshire medical worker had been ordered to self-isolate because he had already tested positive for coronavirus. In spite of knowing that he had tested positive for coronavirus, he chose to attend an event at Dartmouth Business School. His conduct was almost certainly reckless. Now, the requirement of proving contact is a bit more challenging. It is known that coronavirus spreads through person-to-person contact, probably through droplets of saliva or mucus. But it is going to be practically impossible for the infected person to prove that he came into contact with a particular droplet of saliva or mucus that came from the infected New Hampshire medical worker, unless that medical worker actually spit on him. The best argument for the victim in this case is probably to establish that no one but the New Hampshire healthcare worker and the victim tested positive for coronavirus in the entire gathering. Now, everybody at that gathering was actually tested, so this evidence actually exists, and therefore the argument would be that the only person that could have infected the victim was the other person with coronavirus. This type of argument has had mixed results. Some courts will take this as evidence that the New Hampshire healthcare worker was more likely than not responsible for the victim coming into contact with the virus, and others will not. So this is a weak point for the battery case. Damages, on the other hand, are pretty cut and dry. Testing positive for the virus and getting sick, even if it is a mild illness, easily satisfies the damages requirement. So battery is a possible cause of action, but it is not a lock. The contact requirement is problematic, so let's look for something better. Another problem with alleging battery is that battery is what's called an intentional tort, which, to cut to the chase, means that the perpetrator's homeowner's policy, assuming that he has one, would not be on the hook for paying the judgment. In most cases, that means there's no money in a battery count, although that can vary widely from case to case. We don't know who the New Hampshire disease spreader is, so we cannot determine what his ability to pay a judgment is likely to be. Now that brings us to the next potential cause of action, which is negligence. Negligence is probably the most popular count asserted in American civil courts and is frequently asserted in personal injury cases, business cases, property damages cases, you name it. As a preview, this count is going to work very well if someone wants to sue our little Typhoid Mary in New Hampshire. Now, let's go over the requirements for negligence, what we lawyers call the prima facie case. First, there has to be a duty owed by the defendant, our New Hampshire disease-spreading healthcare worker, to the plaintiff. Second, there has to be a breach of that duty. Third, there has to be actual causation, meaning that the defendant's breach has to have actually injured the plaintiff. Fourth, there has to be proximate causation, which means that from the defendant's point of view, a reasonable person could have foreseen the probability that the plaintiff would be harmed by the defendant's conduct. Fifth and finally, negligence requires that the plaintiff suffer some damages. Let's apply these elements to the facts of our case. First, did the New Hampshire man that knew he was infected with coronavirus have a duty to the plaintiff in this case, the other man that became infected? All persons have a duty to behave reasonably under the circumstances. In our case, the infected New Hampshire healthcare worker knew that he was infected, and he had been advised to self-quarantine. Under those circumstances, did he owe a duty to avoid public gatherings, like the business school event at Dartmouth? I think more or less everyone would agree that the answer is yes, and I would expect the plaintiff to win this point pretty much every time. Second, did our coronavirus-carrying New Hampshireite breach that duty? Did he in fact attend a public gathering after being advised to self-quarantine? Again, the answer is yes, and I would expect the plaintiff to win this point every time. Now that brings us to causation. Can the plaintiff show that our malcontent coronavirus-infected medical worker actually caused him to catch coronavirus? And that from the defendant's point of view, it was foreseeable that the defendant's conduct would cause him to catch coronavirus? The answer, a resounding yes on both counts. Let's get into it. In most states, a plaintiff does not have to prove that an infected droplet from the defendant is what actually infected the plaintiff. Rather, all that the plaintiff has to prove to establish the actual causation branch of negligence is that the defendant's conduct was a substantial factor in causing harm to him. And under this test, even if the plaintiff cannot rule out every other person that he potentially came into contact with for a period of a few weeks as the actual cause of the infection, he can argue that the defendant's conduct, attending a business school event at Dartmouth Business School, even though the defendant knew he was infected with coronavirus, was a substantial factor in causing him to become infected with coronavirus. And assuming that the defendant is not able to establish a more likely cause of the infection, I would expect the plaintiff to win on actual causation. Similarly, it is clearly foreseeable that attending a business school event while infected with coronavirus is likely to cause another person to be infected, so the plaintiff would likely win on proximate causation as well. Finally, there is no doubt that the plaintiff would be able to prevail on damages. Being infected with coronavirus is clearly harmful. The real question would be is how much money the plaintiff would be able to recover. Now, what are some of the obstacles in plaintiff's way to riches and glory by suing the pants off of our coronavirus-infected Dartmouth Business School student? The main obstacle, quite frankly, is going to be money. Unless the plaintiff, the man that was infected in our scenario, becomes very sick, then this is not the kind of case that a plaintiff's attorney is likely to take on a contingent fee arrangement. The reason for that is very simple. A fair amount of money is going to be required to get this lawsuit off the ground. The defendant needs to be identified and expert testimony on the spread of coronavirus is necessary. I would expect that a plaintiff's attorney would have to spend a minimum of $15,000 to make this a viable case, and most attorneys will not take on a case like that unless there is an expectation of a substantial recovery. Therefore, the plaintiff would have to suffer some pretty intense symptoms. Nonetheless, under the right circumstances, a case like this definitely makes sense, and you can bet that we are going to start seeing cases like this in the very near future. Now, if you have any questions on any of the issues that were raised in this video, please feel free to post them in the comments. I will review all of them. Finally, if you enjoyed this video or found it educational, a like would be appreciated. And if you are interested in more content like this in the future, please feel free to subscribe and turn on notifications. Goodbye for now, and have a great day.